One of the things that I have learned being in private practice is how important the healthcare industry is to our society, and how fraught it is with danger of fraud, waste, abuse, and that sort of thing, and is a fertile ground for potential liability for white-collar crime. There's just a tremendous amount of money involved in it, a tremendous amount of governmental intervention, and we have with us today, fortunately for the seminar, and for me personally in my practice, two experts on healthcare law are going to talk about these issues. First is my law partner, Alice Harris. Alice is a member of our healthcare group in our Columbia office. She's been with Nelson Mullins, since 1993, when she graduated from the University of South Carolina, where she had a very distinguished record there. She's also a graduate of Valdosta State College down in southern Georgia. I've gotten to know Alice through the law firm, and in fact, we've been working very closely together in the last few weeks on a pricing case against our client. Thank you for joining us, Alice.
Thank you.
And I'm also pleased, and I hadn't met Don Caldwell until today, but I'm also extremely pleased to have Don Caldwell with us. Don is an Assistant United States Attorney in the Western District of North Carolina. He is quite a specialist in healthcare law. He co-authored a book in healthcare law with Judge Horn. He's written some other books and extensively on healthcare. He's a graduate of Davidson College, so were you a native North Carolinian?
Both sides of my family are from Mecklenburg County, yeah.
Mecklenburg County, okay, well, great. And he slipped out west, it used to be North Carolina, out to Vanderbilt University, it's now Tennessee.
That's right.
So, without further introduction, I'll turn the program over. Thank you very much.
Thank you, Judge.
Thank you. It's an honor for both of us to be here today, and it's actually been a lot of fun for us to work together on this. I'm basically in the civil defense area, but as you'll see in this presentation, one of the things I wanted to show you today was how closely, in at least one industry, the healthcare industry, the sort of civil and criminal liability butt up against each other and sort of bleed over. Don and I talked a lot about that. My partner, Holly Pearson, has provided you with, I think, a great paper in your materials related to federal criminal healthcare investigation and prosecution. And Holly actually worked with Don in the North Carolina Attorney General's office. She was in the criminal area, helped us get ready for the presentation. And Don, he works in the civil side, but today at some point he's going to talk a lot about how he brings agents in against the poor providers from the FBI and the DOJ and the OIG and the AUSA. So well, he'll have his chance to speak in a minute. He's also done a really great paper for you as well. Pretty quickly in the presentation, I hope we're going to get to the Civil False Claims Act, which is a tremendously effective tool for the government. I would call it draconian, and I'll do some math for you later just so you can see how quickly penalties can pile up. Now, it's also a positive thing in a way because it does, I think it is a very effective deterrent to abuse in the system, and we're going to probably joke around about our different positions today, but you know, I think for the providers, I think there does need to be a lot of guidance, which the OIG provides on its website. We'll go through that as well. But his great papers in there for you, Q10 action, best practices for Relators Council. He talks about the Civil False Claims Act in that paper, and also sort of gives you a roadmap for any of you guys who decide to go to the dark side and represent whistleblowers at some point, how to put together a complaint and file suits. Now, do we have a lot of students in here? I thought that we had quite a few students today. We might or might not. Well, one of the things that I was trying to think of, and this I think would apply to people out practicing too, if you're not familiar with why we're discussing liability issues in this area, really gives you a great introduction to how the laws apply in a sample industry and why there is so much regulation and such a legal framework. Don is going to give you a great introduction to different enforcement agencies and resources. I might actually ask him some questions about it while I've got him up here, because I think it's really interesting. There's lots of organizational charts on the internet that you can sort of see how the DOJ is the big umbrella and all that, but hearing from someone like Don and how they actually work together as a team is going to be really interesting. I'll try to give you the health provider perspective, as you can see, related to the applicable laws and enforcement efforts. And I think both of us will talk at some point about the interrelation between the civil and criminal enforcement efforts and the deterrent effects. And why, again, is there such a focus? I think everybody's probably read in the paper. There's a lot of cases, a lot of litigation, both from the prosecution and the civil side. In a second, Don's going to talk to you about quickly about the massive amount of money in the United States that we're all aware of that goes through the healthcare system, including government money. The industry receives a tremendous amount of portions from the government, state government, county government, and of course the federal government. And hopefully we'll have time to tell you some of the war stories we've seen or heard reported. I've defended fraud and abuse case. I do a lot of compliance work, try to keep people out of trouble, do a lot of investigative work in the trenches, trying to figure out what to do when we find a problem. And then I think Don's perspective is really interesting on what happens when a case walks in the door, or a provider comes to them and say, oops. Mm-hmm. So I think that's really interesting as well. Let's see, and I think that one of the things I mentioned earlier was just how regulated this industry is. When I go through some of these laws, I mean, we're really just going through pages of criminal laws and laws in the Social Security Act that sort of regulate abuse, but it's also the claim submission process itself, for those of you who don't work in the industry, is incredibly complex, sometimes contradicting itself. But again, because of the money that's flowing through the industry, it remains a significant focus of many different health enforcement agencies. Mm-hmm. I'm going to let Don talk about the national sort of healthcare economics, so give you a sense of what we mean when we talk about just how much money is sort of flowing through here.
Right. Yeah, there we go. The United States, in the most recent figure, has spent $2 trillion on health care in the most recent year for which we have figures. That's an astounding amount of money, not just because you're talking trillions, but what's astounding about it is the percentage of gross domestic product that goes for health care in the United States. When I'm talking about health care, I'm talking about government health care dollars, I'm talking about private insurance dollars, I'm talking about the whole pie. We spend 16% of gross domestic product on health care in the United States. What is astounding about that? You think, well, so what? What's astounding about that is that when you compare it to other industrial economies, they spend far, far less. If you look at what Canada, France, Germany, Britain, Japan spends as a portion of their national pie on health care, it's far less. They spend, more or less 10% a year of their GDP on health care. Far, far less than we do. Now, you could say, well, that's just a social choice. We want to spend more on health care. But what's astonishing is that they have better outcomes measured by life expectancies than we do. And we're spending far, far more money. I think the conclusion you can draw from that is that money is not being spent efficiently. We're not getting the bang for our buck that other countries have been successful in doing. Why is spending 16% of GDP on health care a problem? You could say, again, it's just a social choice. The problem is that it crowds out other social spending that a legislature, for example, might like to devote money to. Education, for example. If you looked at a given state budget 25 years ago and looked at kind of what was the biggest line item was always education, always. In the last 3 to 4 years, in no state is it education. It's health care. So when you're asking yourself, why can't our teachers get a raise, it's because we're spending those dollars on Medicaid, which is a program that has grown and grown, and has grown so much that it now eclipses the size of the Medicare program. And to give you a little more background, and maybe this make more sense if I explain this, Medicare is the program for elderly individuals and disabled individuals. Medicaid, by contrast, is the state-administered program for the indigent. So it is Medicaid that has just grown by leaps and bounds over the last number of years and is just terrifying state legislatures coast to coast. And again, for the first time this past year, Medicaid became larger as a program than Medicare, and it's eating state budgets alive. Now, I just want to make that point just to discuss the economics. The dollars are split between both private insurance and then Medicare, Medicaid, people's out-of-pocket expenditures, other public expenditures, and other private expenditures. The issue of how to finance health care has been a perennial one for American politics for the last century. Theodore Roosevelt was the first one who discussed the possibility of a national health care system about a century ago. That went nowhere, and basically the issue was dropped from the American political discussion until after the Second World War, when in his 1948 campaign, Harry Truman ran on a platform of providing an extension of the Social Security system that would provide health care to all Americans. That initiative failed because of the vehement opposition of physicians embodied in the American Medical Association and by business groups. Many of you are also aware that there was an attempt to develop such a system in the early 1990s, in the early years of the Clinton administration. Again, it was business that was one of the major opponents of such a healthcare system, but what we're beginning to see is change. In the last few weeks, many of you have been reading in the newspapers that General Motors is talking about potentially filing for bankruptcy. General Motors is the largest industrial organization in the world. And they contend that one of the reasons why they're in such trouble is because they have such expensive health care that they provide to their employees. So what's happened as a matter of policy is that you're having large companies that years ago opposed some kind of health care system, whether government operated or otherwise, who are now saying, we're not sure we can continue to survive under the current plan. It's costing us too much money. So I mentioned all of this just to say that the policy pot continues to simmer, and I think it's probably more likely than not that we're going to see some kind of health care legislation in Congress in the next 5 years or so, simply because health care is eating the economy alive. Okay, and then, next slide, okay, there we go. Again, we have a breakdown here of kind of where the money comes from, and again, you see it comes from hospital care, physician clinical services, prescription drugs, nursing home care, and program administration. And then a good chunk of the rest of it comes from dental, other professional services, home health care, and DME, and other services. And the focus that we're talking about today is on federal law, but it's important to bear in mind that there's an overlay of federal laws governing health care, but each state has its own health care laws that have an interplay with those federal statutes. Now, for purposes of federal fraud and abuse law, you have criminal statutes providing for criminal penalties, civil statutes, you have also administrative sanctions. Now, the civil penalties in the healthcare industry are pretty onerous and serve as an effective deterrent to a good bit of fraud. I think that's one reason why we don't have more of it than we do. We also have a number of federal criminal statutes that address fraud, and we have civil statutes as well.
And I've got a couple slides on these are just some of the federal statutes that apply in the fraud and abuse area. RICO, major fraud against the United States, conspiracy to commit offense or defraud the United States. We talked about mail fraud and wire fraud earlier, healthcare fraud, laundering of monetary instruments, theft or bribery concerning programs receiving federal funds, theft from employee benefit plan, statements or entries generally, more false statements related to healthcare matters. Finally really get to the two biggest vehicles that we're going to talk about today, the Civil False Claims Act. We mentioned earlier it's draconian, and I'm going to go through a couple more statutes before we get here, but you start seeing possible $11,000 per item penalties in the healthcare industry, where a physician or a hospital is maybe churning out 10 or 20 of such claims a week over a several-year period. You start racking up pretty dramatic possible penalties pretty quickly. And I put in a notation about obstruction of justice as one of the applicable statutes here. Don and I were talking earlier, and hopefully a good defense counsel will get appointed pretty quickly, or brought in pretty quickly in one of these cases, because I've seen in my practice, and I think Don has too, there are many cases where the federal government can't quite pin down its False Claims Act case, can't really figure out how to put together a mail fraud case, but unfortunately the providers decided to destroy documents or hide documents, and they get wrapped up in a standalone obstruction of justice charge.
That's right. That's not an unusual set of circumstances where you have a provider, whether it's an individual provider such as a physician, a chiropractor, podiatrist, who learns that he's or she's under investigation and decides that the best course of action is to shred documents. That's a problem for that provider. We may not, in the U.S. Attorney's Office, be able to make a case under the original healthcare fraud statute, but we can certainly make a very easy case for obstruction of justice. And that's not an unusual scenario. We see that quite frequently. Often they do it before they've talked to counsel.
Yeah.
They do it in an initial panic when they understand that the agents are at their door and they want to come in and they want to see records and they want to see them right now.
Yeah, and it's just really scary, because we're going to talk later on about how the best approaches for working with, and I was going to say with the federal government when something comes up. I found in my practice that if you find a problem, often the most effective tactic is to be pretty transparent. So here are the documents. Here's what we were doing. Our billing person added this hard edit. We didn't know about it. The government is actually pretty reasonable when you take that tack.
Well, I certainly am.
Yeah, well, we had a side discussion about, there's all people in every industry that give the industry a bad name, and I've run across those too. But Don's approach is, I think, the one that I like to find when I got a government employee on the other side of one of my cases, which is they will take in that information, look at your paperwork, try to understand what happened. And people are human. If you go in as you're human, the provider, and that quote-unquote human, often I represent hospitals or nursing homes and say, we understood this requirement to mean this, or we had this rogue employee. Transparency seems to help. So obstruction of justice, though, is still something that I think providers trip over a lot. I want to go through.
If it's a strong case, it's an easy one to make, and
so
that's something that you need to be aware of in counseling your clients when they come to you in an initial panic.
Right, absolutely. And in one case, actually, during Y2K, I was representing a large provider, and the case had been going on for a couple of years, and I just accidentally found out that they were going to be switching the computer system over and just turning off the other computer. I was like, well, how are you going to save this data? And they're like, what do you mean save this data? I'm like, well, let's sit down and talk for a while. Ended up, in a large provider backing up, saving things, and the government wanted to see all that eventually. They wanted to have access to it, and thank God that, we were able to back it up and have it available. it would have been inadvertent, but still. Now, two very important statutes in the healthcare area that really have changed the way providers put together financial relationships. The first is the anti-kickback statute, which everybody may or may not be familiar with, but it's an intent-based statute. Whoever knowingly and willfully solicits or receives any remuneration, basically anything in return for referring an individual for the furnishing of services that the government might pay for, can be subject to fines of up to $25,000 or imprisoned for not more than 5 years. Again, it's an intent-based statute. And the government has, what I have been impressed with over the last 10 years, the government has tried to, or been told by Congress to promulgate information about how to comply with some of these laws. Being intent-based, the safe harbor regulations basically show for different transactions how you can put together a transaction so that if your intent, again, is above board, can sort of say these are permissible.
And if I could just jump into
sure.
point out that the policy reason animating the passage of this statute and other healthcare fraud statutes has been to reduce the incredible level of inflation that we've seen in healthcare policies and healthcare coverage in this country. All of you, anyone in this room who's been paying for healthcare out of your own pocket and for your business over the last 10, 15 years has seen it has galloped year after year ahead of consumer price inflation. It's always going up far more than any other component of the inflation indexes, and the government's been concerned about that, and it's been that concern that has animated the passage by Congress of a number of these statutes. It's been to reduce, in this case with the kickback statute, to reduce incentives for physicians to take kickbacks to steer certain types of medical work to, say, a particular laboratory that they may own instead of another laboratory that gives them less expensive services that they don't own. So that was the problem that...
Well, and also overutilization. I mean, when we're just talking about physicians,
exactly.
I guess, right now, owns the laboratory or owns the MRI or owns something else. There's ways to structure it so that a physician can own it, can do a lot of things. But this law and then the Stark, the Stark anti-self-referral law as well. The focus on this is to take out a financial incentive to either overutilize or send somebody for a test they don't need, just because that person's going to profit from it. The Stark self-referral law is you're either in it or you're out of it, where the anti-kickback, like we said earlier, it's intent-based, it's kind of gray. The safe harbor regulations are great. A lot of times you're looking at the different safe harbor regulations, you're looking at advisory opinions. You may not be in it, but you can still comply with the law. And
this is a big problem. It's a big problem that we see in our district with physicians buying certain tests, or they will buy machinery that they will use on their patients and to perform certain tests. We've got a doctor we're investigating right now who every person who walks through his office, every patient who comes in, they give them a hemophilia test. Right. Every single one, whether they need it or not, no matter whether they're old or young or whether they feel like they're healthy or not, they all get that test. Why? Because he can bill it and make money off of it.
Right.
This is. You'd think they would know better, but there's a lot of this out there, and it's costing you as taxpayers, or working in private industry a lot of money.
And right before the Civil False Claims Act, civil monetary penalty law is another tool, and I'm going to ask Donna in a second here to exactly how it's used, because it's an administrative sanction, and penalties for all sorts of improperly filed claims. If you know it, or should have known that it was not provided as claimed, based on a code, it's called upcoding in industry, that will actually result in a greater payment that is applicable. It's false or fraudulent in some way. So basically, if you improperly file a claim, the penalties are up to $10,000 for each item or service. And I'm going to do a little math for you in a minute so you can sort of see what that means. And then, on top of that, an assessment of not more than 3 times the amount of claims for each item of service in lieu of damages. Let me do the math for you, then I'll talk to Don about how they use it in his office. Let's say we've got a doctor, and this is a really simplistic example, but he's got basically 5 CPT codes he can choose from. 99241, which is sort of a very quick consultation, not a whole lot of time. These are actually time-based codes. I think 99245, you're spending up to 80 minutes with that patient. 99241, maybe only 10 minutes. Mm-hmm. The Dr. X is usually his work could support maybe a 99243, 992. I meant to put 99244. He's spending some time there, but he decides, I want to always bill 99245 because I get, twice as much. So maybe over, he bills 5 consults a week over a 5-year period. And I'm not a big, I went to law school because I don't like math, so I hope I did the math right. I have to tell Walter and I were working late this week on some cases, so I was doing this at 9 o'clock at night. But assuming my math is correct, but it'll give you a rough estimate. Let's say the difference in that 5-year period was, for those claims, was about $30,000. Well, that's great. Well, Dr. X made an extra $30,000. Well, the government comes in and says, well, we found out you're doing this. Your nurse came in, and she's not filed a key tam suit, but she's come in and told us that Dr. X, by the way, you just fired this person. Another good way to create a whistleblower. Well, we could do a whole new seminar just on that. So they say, okay, well, first of all, we want our penalty. 1,200 claims times 10,000 is $12 million, I think. And then we also want, the amount of damages, which is $50 times 3, and then you got the total, just these penalties. We haven't even talked about attorney's fees. We haven't talked about, any other possible damage there, of over $12 million worth of exposure. And this same math, as you'll see under the Civil False Claims Act, is going to be the same. I mean, I was in a case a few years ago. The government estimated that my client owed, I think it was $600 billion or something like that. I mean, quickly, if you've got this is just a simple doctor, and that's only 5 years, 5 times a week, but let's say you've got a nursing home or a hospital or a large provider practice, and they decide, gosh, I get more money for this code. Well, hopefully somebody has a compliance hat on to say, well, maybe that's not such a good idea. Let's sit down and talk about it. And so before we go, we're going to go to talking about exclusion, which means, Dr. X, you can no longer bill for Medicaid and Medicare ever again. We're going to talk about how do you use, we talked about civil and criminal statutes. That's pretty easy to understand. But the administrative civil monetary penalties, tell me a little bit about that. Okay,
those are usually not really within the purview of the U.S. Attorney's Office. Those are penalties which are imposed administratively by the Office of Inspector General of the Department of Health and Human Services. And so those are ones that are really negotiated not within a law enforcement context. Those are ones that are typically done administratively with the agency itself. And also, to make it, I know that those figures sound stratospheric and it does sound draconian in a lot of ways, but you do have a right to appeal administrative penalties, and those are typically resolved downward significantly, has been my experience.
That's been my experience too. I mean, what is likely to happen here is that they'll say, do you realize your exposure is? Kind of gets everybody's attention, everybody in the room, to really seriously start thinking about this. But we'll also talk about some more stories a little bit later about that one case you were telling me about, the cardiologist recently. Mm-hmm. And large amounts of money flowing in here. But another thing that Dr. X could be subject to is exclusion from the government health care programs. There's mandatory exclusion if the individual's convicted of certain criminal offenses, and those are outlined in the statute. And basically, the OIG, which Don mentioned earlier, has no discretion. Once you trigger an underlying trigger, then a 5-year minimum exclusion is imposed. More often, there's permissive exclusion authority, and actually, as we were talking, Don and I yesterday, trying to get together what we were going to do today, I get all sorts of alerts. This is a Medicare compliance alert. The OIG had just excluded its second hospital, and that's extremely rare. The OIG looks at hospitals. I mean, that's a community provider. It's more than likely going to cause the quote-unquote death of that entity and the death of that person's career. So that I know that the OIG takes these very seriously. The OIG excludes an average of 3,000 to 3,600 providers a year, and the majority of which are smaller physician practices, home health agencies, and clinics. But this hospital, South Beach Hospital in Miami, is the second hospital in 30 years that's been excluded. They were under another thing that the government will often do in a settlement of fraud and abuse claims will make the provider enter into it's usually a 5-year corporate integrity agreement or ICA, institutional compliance agreement, where that provider has to submit reports to the government, do certain auditing, basically set up a compliance program and submit to auditing. And this hospital got excluded because it submitted its reports late. It sold the hospital without telling the OIG. It was just an explicit provision in these ICAs. It failed to retain the independent review organization that was supposed to come in and look at their coding. So it was a pretty egregious case, but that's yet another thing that can happen. And I was working on a case a few years ago. The civil case had gone on for 5 years, and at the end of that, the exclusion stuff started. So it's just one thing after another. We knew that the criminal was also looking at the case at the same time. So all these, we were sort of talking today about white-collar crime. Well, it's kind of blurred in the healthcare industry, maybe in the defense industry too, I bet it is. But you've got the civil case going on, and the criminal's watching through the similar discovery process, and then the OIG's looking, and so we ended the civil, and while we were doing the wrongful discharge trial, which was the relator-only claim, we had the exclusion going on and trying to respond to the plaintiff's relator's request for attorney's fees. So very costly.
Well, if you are defense counsel and you know that you're representing a provider, a physician, an institution such as a hospital, and you feel like that you may have some criminal liability, and you are pretty certain that you've got some civil liability. In other words, you know that you owe the government some money. You can come to the U.S. Attorney's Office and say, we would be interested in doing a global settlement. Those are magic words. I, as a prosecutor, cannot say to you, would you be interested in trying to work out a global settlement of civil and criminal claims? That is an ethical violation for which I will lose my job, because it will look as though I am trying to extort a civil settlement out of you for purposes of resolving the criminal aspects of the case, or that you're trying to buy your way out of criminal indictment. I cannot say those words to you. You, as defense counsel, however, can say, we would be very interested in a global settlement of civil and criminal aspects of this case. We're in business.
And they can say no.
We can say no. We can say the facts of this case are so egregious that we really we want to sift through some more evidence. We want to find out what else is going on here. But you need to understand, if you're dealing with the U.S. Attorney's Office, that you cannot sit there and wait for the AUSA to propose a settlement of all aspects. Although typically your client is the one who's saying, how do I get out of this? how do I just wrap all this thing up? Well, what you need to do is go to the assistant U.S. attorney and say, we would be interested in talking with you about a global settlement. Global settlement. Let me say that one more time.
Everything.
Again, the AUSA cannot ethically use those words or initiate that conversation.
And they are receptive to talking to you.
And so good defense counsel is going to come to you and say, we would be interested in initiating some discussions along those lines. And often the AUSA is waiting for you to say something like that, and when you don't, he's puzzled. It's you can't write it on a little sheet of paper and hand it over. You're walking a line there. So, in healthcare cases, often when you have violations, there are criminal statutes that have been violated. There are civil statutes that have been violated. And I think probably the most important of all the civil statutes that you need to be aware of is the Civil False Claims Act, which is 31 U.S.C. Section 3729 et sec. The Civil False Claims Act was passed by Congress in 1863 at the height of the Civil War. The Union Army in the Civil War was ordering barrels of gunpowder. So what were they getting when they were delivered to the battlefield? They were getting barrels of sawdust. And the Union was losing the war. It was losing lots of money. It was getting ripped off. So Congress passed what was then known as the Lincoln Law, the False Claims Act, that provided for the government to recover these dollars and to get, at that time, double damages. In other words, if you stole $100,000, the government could get back $200,000 back from you. Now, it was not that widely used until the 1980s. How many of you remember during the Reagan defense buildup, the scandals that we would read in the papers about the $400 toilet seat with the $30 wrench? You remember that, guys? Okay. Congress saw this, and they were outraged like most of the public. And they said, we can't balance a budget if we're paying $400 for toilet seats. So Congress said, we need to amend the Federal False Claims Act. They rewrote the statute, moving it from double damages to treble damages. And they targeted it not only at defense spending, but any kind of government spending, any kind of government contract. Well, initially the cases that were being brought by the government were against defense contractors who were overcharging. But it became evident over a period of time that really the big money was not going out the door to pay defense contractors. It was going to medical providers. If you look at where federal dollars go, it's to healthcare providers, whether hospitals, clinics, physicians, chiropractors, the whole range. And so the Department of Health and Human Services, working with the Justice Department, said we need to start looking more carefully at the flows of these dollars going out of the federal treasury. And so in the late 1980s and the early 90s, you saw a big push to try to identify fraud within the healthcare industry. And I'd go so far as to say it's been pretty successful. I'm not saying that there's not fraud out there that we're not seeing, but we're targeting it, and we had the resources to go after it now in a way that was not the case before. The Civil False Claims Act provides that any person who knowingly presents or causes to be presented a false or fraudulent claim for payment, knowingly makes a false record to get a false claim paid, or conspires to defraud the government, should be liable for treble damages or $10,000 and $10,000 per claim wrongfully submitted. So again, you've got huge civil liability there. If you're talking millions of dollars, even to individual providers who have been defrauding the government. And you need to know that for purposes of the Civil False Claims Act, knowingly is defined very broadly. This is not a specific intent crime. If you show reckless disregard of the truth or falsity of your bills, then you're liable under the False Claims Act. I'll give you an example of that is the Kryzek case, K-R-I-Z-E-K. Dr. Kryzek was a psychiatrist, I believe, in New Jersey. He had his wife doing the billing for him in the office, and she would submit bills. He didn't pay that much attention to them, and the bills were far more than for what the work was that he had done. It alleged that he was in the office certain days when he wasn't, that he billed for the time that he allegedly did during those days. And he asserted in his defense when his case went to trial that, well, I really didn't know what I was doing. I wasn't watching that carefully. I really delegated that to her. And the court was very clear that deliberate ignorance of the billing statutes is not a defense. And the court said, you may not be an ostrich.
And then actually, we were talking about this yesterday, Don and I. It actually changed the way I think physicians practice medicine. Many physicians, when they were starting out, they didn't have to worry about what was being billed. They did their work, they went home, and the billing office took care of it, or their nurse or their assistant. And when I first started out in this area, a lot of providers, not just physicians, would say, well, why do I have to know what code? Why do I care? And it's the ostrich thing. If you don't care, you don't know what's being billed under your name, you don't know the difference between the available codes, you're either being reckless, or you're sticking your head in the sand. And so, it's been interesting to see in the industry now. There's a lot of focus not only on compliance efforts and education and training, but a huge effort to help providers with tools that that actually lay out the different codes for them and a description of them as they're doing their work, checking it besides that. So it went through a pendulum swing where I think people felt like physicians just had to know everything cold, to where the industry recognized that there could be tools to make it a little bit easier.
And this is not as complex, I think, as providers sometimes make it out to be. They always say, well, there's this big, enormous book full of, so like a telephone book of codes. Well, yeah, that's true, but the thing is, if you're a psychiatrist, you only need to know 5 of those codes, because only 5 apply to you. If you're a pathologist, only 5, 6 of them apply to you. So it's not really that complex.
Oh, no. I know for somebody who's had to figure, when I get in, as for those of you who may work in this industry, and whether it's in compliance mode, or investigatory mode, you got to go in there and figure it out. Well, CMS, has 5 manuals, and you're in a hospital, and the physician's doing it, and then the state has its own guidance, and it's changed 5 times in the past 10 years, and there's 20 codes you can choose from. And the difference in the codes is maybe one element, and are they documented, are they not? I mean, it is very complex, so let me tell you.
We're not generally very receptive to that argument.
Well, believe me, we have a difference of opinion on that. Okay, so anyways, false claims can include a variety of different things. The data in the document itself, services performed when they're not medically necessary. Again, that kind of stems from what we were talking about earlier. Performing something either for financial reasons, that test you were talking about, that the doctor was billing on every patient, whether they needed it or not. There's a pretty famous case in the industry, I'm not sure the name of it, where the doctor was billing at nursing homes for nail trimming, but the person didn't have any legs. So they're pretty dramatic.
Yeah, he'd had his legs amputated years before, but the podiatrist was billing for cutting the man's toenails.
That's a pretty famous case. Pretty easy to prove, I think. I think even I would be like, I think that's pretty clear. The Civil False Claims Act, the damages again. I mean, we're talking about $11,000 per claim. We talked about how that can rack up pretty quickly. In addition to damages on any given case, I mean, there's legal fees related to the defense of the matter. That's your defense. The possible payment fees and costs to the relator. We'll talk about the whistleblower, I think, in the next slide or two. And more often than not, the court will order you to pay their fees, attorney's fees. Damages related to wrongful discharge claims is often a separate suit on that. And then the ICA we talked about earlier, there's a lot of costs related to that. Some of it you need to have in place anyways. Every provider of any size needs some sort of a compliance program. And if we have time, we'll talk about that. We may run out of time here. I'm going to get to the key TAM provisions. Okay. Talk just for a second on what that means. We've been talking about key TAM this, key TAM that. Well, what does it mean?
Okay.
I flipped on over to.
Okay. Qui tam basically is a Latin term referring to a type of suit that was brought in medieval England that an individual could bring in the name of the king, because there wasn't much of a constabulary in the Middle Ages. So you could, in the equity courts, file a lawsuit in the king's name. And when we immigrated here, we brought all of that common law with us, and that's part of it. And the qui tam litigation originally was criminal in nature. There have been court decisions and congressional action that have moved it to the civil realm now. Qui tam is a fancy way of saying a whistleblower suit under the terms of the False Claims Act. A qui tam action is brought by a person who, in this context, the whistleblower is known as a relator. He relates the information to the government. How does he do that? The relator files a lawsuit under seal in the federal district in which the alleged wrongful activity occurred, and files it under seal and serves it on the Office of the United States Attorney for that district. He also serves it on the Attorney General in Washington. Once it is served on the United States Attorney's Office, the U.S. Attorney's Office has 60 days in which to investigate that case. A clock starts running. You've got 60 days. You've got to get agents in, and you've got to start investigating that case. Now, they're frustrating cases for us sometimes, because often we'll have a great case that we're working on, that we've been working on for some time. We're developing it. We've got documents. We've got witnesses. And then out of nowhere, here comes this qui tam case that's been filed, which may or may not be a good case. But whether it's a good case or not, we've got to investigate it for 60 days. And so we've got to get together our agents and determine whether there's a case there, and is it one we want to go forward with or not. Now, when a qui tam case comes to us, we've got a couple of choices after we investigate it. The United States can intervene, meaning we take over the lawsuit and step into the shoes of the relator, or we can decline to intervene. Now, in 70% of cases nationwide, the government declines to intervene. What does that mean? It means the government says, we don't want to spend our time and resources on this. Maybe we don't have enough people to do it. Maybe we don't think it's a very good case. But if the government declines, the relator or whistleblower can go forward with the case and recover whatever monies they're able to get. Now, let's say that the government intervenes, we recover some money. What does the relator get out of this, the whistleblower? Well, money. That's why they're doing it. If the government prevails against the defendant, the relator gets between 15 and 25% of the dollars recovered. If the government declines to intervene and the relator takes it on and litigates it itself, it can get up to 30% of the dollars that are recovered. This provision is one that I think the Justice Department has very mixed feelings about. If you talk to the average assistant U.S. attorney, you have relators that come to you and they are just some of the most admirable people you'll ever meet. I had one a couple of years ago. She was a nurse. She was seeing things that were going on in a home health agency that should not have been going on. At risk to her job, she called the she called the corporate office and talked to the in-house counsel and said, "You guys are doing things here that you shouldn't. They're illegal. You really need to stop this." And they blew her off. And they said, "Don't waste our time." Well, she filed her suit. She was a registered nurse. She was concerned about patient care. We intervened in that case. We recovered $865,000, and I really admired the woman for doing that. She took a great risk, and as a result, she recovered, or allowed us to recover, money for the Medicare Trust Fund, which is going to go to pay for health care for elderly people in this country. By the same token, you'll get relators who come in who are not exactly Snow White. We had one in a recent case who came in who, she was the physician's office manager. She and he had a falling out, and she'd been doing a lot of things she shouldn't have been doing, and she had a good case, but again, she was not the most admirable human being who's ever walked in our door. So these cases, you can get good ones, you can get bad ones, but nonetheless, we're required by the law to sift through all of them to determine if there's anything there. These cases, again, most of them are declined. When we investigate healthcare fraud cases, whether whistleblower or otherwise, we work with a number of agencies in order to do this. And I'm proud to say that in our district, we have a very cooperative relationship among the different agencies and with the state attorney general's office. So we really work as a team. Generally, when a case comes in, we get together and try to assign agents who will work together to do that investigation. We draw those agents from the FBI, from the IRS, from the North Carolina Department of Insurance, from the North Carolina Attorney General's Medicaid Fraud Investigations Unit, from the United States Postal Service Office of Inspector General, the Office of Personnel Management Office of Inspector General, the DEA, and the Defense Criminal Investigation Service. So we've got a lot of people who are working with us to develop these cases because the Justice Department has put such a high priority on these kinds of cases. The dollars lost are so big that it feels like that it has to devote these resources to it. On the next sheet, how cases come to us. Often we get the agents or we will get phone calls saying, you know, there's this, you wouldn't believe what's going on in Dr. So-and-so's office. You know, he's billing for work he never did. You know, he's on the golf course these days, but he's billing for all this work, and, you know, you guys really need to look into this. So you get those kinds of hotline phone calls. You have agents who bring in cases. You have, again, the whistleblower suits. And they're handled by assistant U.S. attorneys. Typically, we'll have a criminal assistant who will work on the case and a civil assistant who will work on the case. And what we know as a parallel proceeding. And so we let the proceeding go forward. We let the agents work together and develop the case and try to bring it to fruition. Once we've done the investigation, we have to make a decision. Is it a criminal case or is it not a criminal case? Criminal always goes first. Is it a criminal case or not? If criminal decides to go forward, they will indict and move forward to trial or to a plea. If we determine that there's not a criminal case there, then civil takes it over and tries to determine, are there dollars that can be recovered for the benefit of the Medicare trust fund. Let me talk just a little bit about...
Before you leave that, can they proceed in tandem? Let's say you have a civilian attorney who's representing a relator in a fairly substantial case, and then the criminal gets in there and says, there's criminal overtones to this, we'd like to take the case. Can the civilian attorney and the relator go forward on the civil?
Usually what we do is we ask the court to basically put that on the back burner. We'll ask them to basically stay it or keep it under seal indefinitely to allow us to continue to do the investigation. And then once the criminal aspect of it has been completed, then we ask the court to unseal it or unstay it. On the next sheet, what kinds of typical cases are we seeing in the criminal healthcare fraud area, and kind of what have been typical defendants? We're seeing a lot of home health agencies, a lot of wheelchair cases in the last number of years, or what we refer to as DME cases, or durable medical equipment. I don't know, you probably have seen ads on television late at night. Do you need a wheelchair? Well, Medicare will pay for it. Dial 1-800. Operators are standing by. There's a huge scam going on now where you have physicians who will write those prescriptions for those people to get wheelchairs, whether they need them or not. A lot of these scams started in Houston, some to a certain extent in Los Angeles, and like so many of these scams, they move across the country. We're seeing them in Charlotte, where you see the ads, you see people, doctors who will take kickbacks to write these kinds of prescriptions for wheelchairs for people who don't need them, or for the most expensive type of wheelchair, the K11 wheelchair, which very few people really need. These kinds of scams have been the province of a number of gangs, particularly Nigerian gangs and Russian gangs, have set these things up around the country. So you've got a lot of criminal activity that you would not expect to see really in the realm of healthcare. But again, the money is so big that you have criminal gangs that say, there's a lot of money to be made. Let's get our cut of this. We're seeing a lot of ambulance company cases in which ambulances are billing Medicare, Medicaid for services that they're not allowed to bill for. For example, if you're transporting someone to the hospital and it's an emergency, of course you can bill for that. That's what ambulance companies are for. But you will have people who, or companies that bill to take people to maybe a nursing home to visit a relative or to the grocery store. I mean, you wouldn't believe the kinds of billings that are submitted. Medicare pays them, and then we've got to go back and try to get that money back. There was a conviction in the U.S. Attorney's Office, U.S. District Court in Raleigh just last fall in a case, and there's the operator of that hospital ambulance, or that ambulance company is going to be going to prison for a number of years for billing for these kinds of just outrageous services. I mean, it's blatantly fraudulent. You have seen a lot of crime associated with for-profit healthcare hospitals. How many of you a year or so ago saw the segment on 60 Minutes about Redding Hospital in California, owned by Tenet Healthcare? This was a hospital in which they learned that they could make a lot of money if they could just do more heart surgeries, bypass surgeries. And so they would bring people in, and whether they needed the surgery or not, they'd give them a quadruple heart bypass so they could bill it. Now think about that. I mean, think if this were your mother or your father, and they were thinking, gosh, we can make a buck by doing the surgery on this person who doesn't need it and risking their lives. So you're beginning to see people who are not only committing fraud, but doing things that are medically dangerous to patients. This was unthinkable, and you just didn't see this a couple of years ago, but it's something that we're seeing more now than
on
we used to.
the Redding Hospital Medical Center, what I didn't realize, that was one of the hospitals that they were, this article was talking about when we were talking about exclusion. And the way, apparently from the article, the way Tenet sort of avoided exclusion, because obviously that's a pretty dramatic case, was that they sold that hospital to another provider. It's pretty dramatic. One of the things, and we need to wrap it up.
Right.
Tom and I could talk all day. We talked for an hour and a half yesterday. So it's such an interesting area, we think. I don't know. Probably like, oh, I need a break. But Holly's paper, Holly Pearson's paper, goes through some really interesting settlements and acquittals. Now, the prosecution success rate is actually about 90%. I think a lot of people who read the papers might think it's less so because of the Richard Scrushy and TAP pharmaceutical employees cases. Some high-dollar settlements in there. Just for fun, anybody interested in this area, there's a Taxpayers Against Fraud website, TAF, and it is a, how would we characterize
It's the Relators Bar.
The Relators
It's the attorneys
Bar.
who represent the whistleblowers.
And they've got a really interesting website. They've got their own statistics. They think the DOJ, you saw those great big numbers when I was flipping through slides, they think the DOJ is actually underestimating how much money's been recovered, underestimating how much relators are getting. You can donate to the Relators Bar if you'd like on the website. They keep their own journals, and as defense counsel, I think it's fascinating. So just for fun, that's another source. We're not going to have time for it, but the OIG has a great website. Got compliance guidance now for about 10 industries or more. 2 different versions for hospitals alone, telling you how to set up compliance plans, what elements they want to see, risk areas. The OIG publishes a work plan every year. They'll tell you what they're looking at, and that's pretty accurate. So every year, as soon as that comes out, we get an email. We're like, oh my God, what are they after now? We go through that. It's good to see the focus. You guys are showing us what you're interested in. The fraud alerts, the joint ventures, for example, have been the subject of fraud alerts many times. Advisory opinions, they do issue through a regulatory process. Advisory opinions, it's really only supposed to be binding on the government and the person who requested the opinion. but almost every day, an ambulance company or hospital or physician practices will say, here's my transaction, what do you think, government? And the advice comes out, and it's actually something, practically speaking, that a lot of people will look to for guidance. So the OIG website's another one. So I am going to leave us with Don's predictions for the coming year, because and when Don gives you a prediction, it's basically, let me see if I can get to the slide real quick, because we were going to talk for a long time, you guys. Don's predictions. Okay. So here's his top 4 predictions for the next couple of years.
These are not just my predictions, but predictions of others in the Justice Department of what we can expect to see in the area of healthcare fraud in the next couple of years. Number one, you're going to see more states passing their own False Claims Act statutes, patterned after the federal statute. Why is that? As I told you earlier, for the first time last year, Medicaid state dollars going out is bigger than Medicare. The government's been concerned that we've not been doing a great job of trying to crack down on Medicaid fraud, in other words, fraud against the states. So you're going to see the states passing their own False Claims Act with their own Ketam whistleblower provisions inside those acts. So you should look for that. There was language tucked into the Deficit Reduction Act a few months ago encouraging states to do that. Second, with the prescription drug benefit that went into effect this year under Part D of Medicare, you're going to see a lot of prescription drug fraud, and we're already gearing up to focus on that. Again, it's so much money, so many people trying to get their hands on it. Third, I think you're going to see some improved information technology systems to curb fraud, and that's a good idea. That's something that, we've got some great technology. Let's try to use it in ways that will try to minimize fraud. And fourth, I think you're going to see more cases against nursing homes focusing on quality of care issues, particularly where there's evidence of patient abuse or neglect. I think you're going to see more attempts to focus on staffing issues and making sure that nursing homes are adequately staffed for the patients that they're caring for. Thank you for your patience with me.
Why don't we take just about a 2-minute break in place and we'll get ready.